The FBI recently conducted a search to seize 2020 election records in Fulton County, Georgia. Here's the problem. I was a federal prosecutor for 30 years, and you don't get a search warrant unless there's probable cause to believe that a real prosecutable crime was committed. The affidavit submitted in support of the search warrant application in this case identifies two federal laws it says might have been broken. First, a law requiring election records to be kept for 22 months after an election. This warrant was sought more than 5 years after the election. The affidavit says certain records are missing now, but it doesn't allege they weren't retained during the required 22-month period. Second, the affidavit identifies a crime related to fraudulent tabulation of votes. It repeatedly says irregularities cited in the affidavit would be crimes if they were intentional, but if is not evidence of intent. A finding of probable cause requires valid evidence of intent, not speculation. And there's another issue. Any prosecution now of the tabulation offense would be barred by the statute of limitations. When DOJ applies for a search warrant without identifying a viable prosecutable offense, it raises serious questions about whether it's abusing criminal process, and that should concern everyone who cares about the rule of law.